the issue. We're trying to figure out how to work it out. This is Anita Casey at the State Bar Office. I want to welcome the participants to our fourth and possibly final judicial regional webinar. The judges today are from our Eastern Panhandle. Monica Haddad, our State Bar President, will introduce them momentarily. We are being moderated today by the representative from the Eastern Panhandle, Jay Gary. I will be taking questions today. If you have any questions for the judges, please email them to me at caseya@wvbar.org. Again, that is caseya@westvirginiabar.org. They should be sent in a question format. When they are received, I will periodically interrupt Mr. Gary and present some questions that are outside the scope of questions which he has to present to the judges. The presentation today is worth 1 credit in law office management. I keep reiterating for people to remember that you do not have to have 3 hours in ethics. You have to have 3 hours in one of 4 categories. Ethics is one, law office management today is another. The other 2 are elimination of bias and attorney wellness. I will provide you with information at the end regarding how to get your hours, but right now I will turn it over to State Bar President Monica Haddad for her introduction of our moderator and our presenters.
Good morning, everyone. Welcome to one of our last webinars in this COVID-19 series that we've been able to put on for all of you since we've been affected by the coronavirus. We started these webinars shortly after the declaration of a state of emergency, and our courts were physically closing down. And now that they're physically reopening, we thought it was a great time to get our judges from around the state to have a conversation with all of you. We started these webinars, they were more in the areas of substantive area of law, coronavirus legislation, and that type of thing. We moved into doing these panel presentations, beginning with the Supreme Court, which was great. We had almost 1,000 of you on our Zoom call, which was really nice to have so many from around the state. And then our Board of Governors had this great idea to do these series of panel presentations with judges from regional areas. So this is the 4th one that we've done. We've hit all corners of the state. So this is the Panhandle webinar presentation. And at this time, what I'd like to do is introduce the moderator and also your judges that will be presenting here today. So we have Jay Gary. Jay is your District 16 representative, so he represents all of you to the State Bar Board of Governors. Since graduating from law school from WVU in 1982, he practiced with his father at Geary & Geary in the areas primarily of real estate, commercial transactions, and criminal abuse and neglect proceedings. Our judicial panel, thank you judges for being here with us. They first include the Honorable Charles Carl. Judge Carl is the Chief Judge for the 22nd Judicial Circuit, Hampshire, Hardy, and Pendleton counties. He has served as a Circuit Court Judge since 2013 and has served on the Business Court Division. He presently sits as the Drug Court Judge of the South Branch Valley Drug Court. He also serves as Vice President of the West Virginia Judicial Association. Judge Carl is a graduate of the Capital University Law School. We have the Honorable Michael Lawrenson. Judge Lawrenson has served as a Circuit Court Judge for the 23rd Judicial Circuit, Berkeley, Jefferson, and Morgan counties since 2012. Prior to that time, Judge Lawrenson was a law clerk for the U.S. District Judge Charles Hayden in the Southern District. And before practicing, after that, he practiced for 25 years in the Martinsburg law firm of Bowles Rice. Judge Lawrenson is the chair of the Business Court Division, and he presides over the Adult Drug Court in Berkeley County. He is a graduate of the WVU College of Law. Finally, we have the Honorable Lynn Nelson. Judge Nelson is a Circuit Court Judge for the 21st Judicial Circuit, Grant, Mineral, and Tucker counties, where he has been holding court since 2008. Prior to that time, he served as the Mineral County prosecutor for almost 20 years. He is a graduate of the WVU College of Law. Thank you, Jay, and thank you, judges, for being here today.
Well, thank you to everyone, and I certainly appreciate Anita and Monica this morning getting things started, and especially to our panel of judges as we take a look at some of the issues that we've been confronted with. Looking forward to how we're going to deal with a few things in the next weeks to come. What I'd like to do initially is ask Judge Carl to give us a little opening comment. Maybe you could give us an idea of what COVID-19 did to your caseload, and what sort of momentum you got geared up for moving ahead.
Thank you, Jay. First, it's a pleasure and honor to be here today speaking to the bar. I can tell you what we did in the 22nd Circuit. Of course, when the COVID-19 pandemic began, no one was prepared. When the administrative order came out, we continued the cases at that time and kind of punted it to try to figure out what we were going to do. Looked at continuing the cases, looked at all the technology that was available, got with the county commissions, the health departments, started that process. Went to Skype hearings, went through the technology processes. We sent letters, or rather emails, to our bar to let them know what we were planning on doing, but we were up in the air. Everybody was. Continued most of those cases to the end of the first expiration date, and of course, when the second order came out, didn't do that. And since that time, we've been conducting the Skype hearings. Just actually today and yesterday, I've had criminal in-person sentencings and plea hearings here in Hampshire County. We've been doing adjudicatory and dispositional contested cases as well. But we've, our docket is a mess. Trial dates are hard to come by, and we're working, of course, with the other judges, Judge Nelson over in the 21st and Judge Currier, and to some extent East with Judge Lawrence in circuit. But we're all scrambling for you attorneys, and we realize what you're up against, but I hope you realize what we are as well. We're doing our best to get things scheduled, and we're progressing under the COVID-19 protocols, and that's how we've resumed operations. That's the main question I've been getting, is what are we doing going forward? Well, we've done a local administrative order here in the 22nd Circuit that's getting attached to the notices of hearing. Putting it on you all, the attorneys, we're dependent on you to help us. You need to make sure your clients know to wear masks, and any audience or public that wants to come with them. We're still observing the COVID-19 protocols with the number of people allowed in the courtrooms. And we've just tried to keep the attorneys informed of those things and what we're doing. We've got all the other standard protocols. We've got the hand sanitizing stations. You may be temperature checked at the doors of the courthouses and whatnot. But, I do want to thank the attorneys and their clients. Really, everybody's cooperated freely and very openly with us. And we haven't had a whole lot of problems as far as integrating back in. But our dockets are tied up. We're struggling to get. I know your alls must be, but I think that with the open line of communication with the judges and with the circuits, it's working out pretty well, trying to get things caught up. We've changed a little bit of our format now. We're contacting through the judges' offices to set the hearings. In the past, our circuit clerks have done the scheduling, but some of our hearings are Skype now. Some are we've actually done leader phone and also in person. So we're scheduling through the judicial assistants in our offices now till we get through the COVID pandemic here.
Thank you. Judge Lawrenson, have you had any changes in how you're getting into the courthouse and the courtroom over in your courthouse?
For the public, the change has been you're going to get asked what hearing you're coming for. The judges and magistrates give our marshal's staff a list of the dockets, and the person's expected to attend for in-person hearings. So at the front door, you're going to get asked what is the nature of your business. Now, we have a judicial center, so we don't have any combined county function with our building. So our building solely houses courtrooms and the associated clerk's offices, prosecuting attorney, and probation. If you have folks that you're going to want to have come to your hearing that aren't parties or witnesses, it's good to clear that in advance so that you get on the list and can be admitted. So getting in has changed. We do have a series of questions that are asked for folks coming into the courthouse to determine whether or not there are any risk factors that need to be explored. You will be required to have a mask, and while it's hope that you'll bring your own, and most people do, we do have some supply of masks available, temporary masks or reuse or disposable masks that can be used for the purpose for folks who don't come. We really need to have them available for our hearing. We haven't yet. We just recently came back online because we were in one of the red counties here in Berkeley, in Jefferson. So our in-person hearings, I think we're only into it now for 2 weeks, if memory serves. But before then, it was all Skype. So the courtroom door was literally finding us on your phone or using the link with a Skype invitation to join a video presentation. We did a little bit of leader phone, but Skype has been more helpful in the sense that it allows us to know who's online. If someone drops off of a telephone call, you wouldn't know it. But if someone drops off a Skype call and it's someone who needs to be involved, then you will know that person is no longer there. And sometimes there are dropped calls or dropped video feeds. So it's good to know who's there.
Have you had any resistance, Judge, with the change in entry at the courthouse with any attorneys or litigants or other persons that might want to come in?
No, actually, and even though you're supposed to get the list in writing the day before to the marshal staff, if they'll call up if someone wants in that wasn't on the list. If we got space, we'll let them in. I mean, these are public proceedings. We are anxious that we not do anything that would appear to affect the transparency of the process, but our goal is to make sure that we have the people we need to have, and then litigants, especially for events like sentencings or whatnot, they want to have their families there, and oftentimes they won't make decisions on who's going to present in terms of statements in support or victims impact statements and that sort of thing. They often make game day decisions on that. So we're trying to be flexible if we can, but obviously we have a ordering of folks that we absolutely need to have in order to conduct the business of the court, and we have to give them priority to the extent that space permits. And we have a luxury of space here. I think we're in pretty good shape. I can't remember hearing where, and I'm not aware of any instance where someone was refused admission that wanted to come see a hearing on the basis that we just need their space.
Judge Nelson, I know down in Mineral County, it's a little tight there getting into the courtroom. Have you had to implement any changes in your circuit?
Well, I mean, we've done similar things to what Mike and Charlie have talked about. Basically, what we have is people come to the front door of the courthouse, because I do a call docket. People come to the front door of the courthouse, they register, then they go outside and wait in their car or whatever, and we advise the bailiff who's going to be next. We bring one outfit in at a time. When they leave, we bring the next outfit in. Now here in Mineral County, we actually have a young lady who cleans off the defense table and chairs and all that stuff in between hearings. But we have not, as Mike said, we haven't any problems as far as people wanting to get in or causing problems, what they have to do to get into the courtroom.
You found that the litigants and the public have been pretty receptive to the new rules?
Yeah, I find that people in this area in general have been accepting of the new rules. I mean, everybody's been patient, everybody's been good to get along with. You know, fortunately, where we live, we social distance a little bit anyway. So I think that we're kind of used to it, and it has been that tough for some people. Say if you live in a 500-room apartment building in New York City.
Well, there you go. I know with that kind of setup, you've had to have some more bailiffs. Has that been working out okay?
Well, we've been handling it with 2 bailiffs. We have one out there at the door who gets in touch with the people who need to come in and brings them in and out, and we have 1 or 2 in the courtroom as well. And so far, the sheriff's departments have worked with the health departments, and we've had no problems with anything so far.
Judge Carl, you mentioned earlier you were conducting a good many of your hearings by Skype. What kind of hearings have you been conducting by that method, and do you see that as a likelihood moving forward as well?
We've been using Skype for Business to conduct most of the hearings that I kind of took the position that if it was a hearing that didn't require the taking of evidence, that I would do it by business Skype. I've actually expanded even on that some, but we've been doing a lot of the status hearings, scheduling hearings, anything that we can. We've done that method. And like Judge Lawrenson said, we found it to be very effective. We've been able to run our dockets. We've been doing business all along through this because of that technology. So what I haven't done, as I said earlier, I'm not really comfortable yet, not saying anything's written in stone, but the plea hearings, felony pleas, sentencings, and where, as Judge Lawrenson said, we've let the public come in as long as we're keeping social distancing and they're wearing masks and whatnot. But I think it's good for reviews on juvenile cases when they're in placement. I mean, there's a lot of use for this that I'm hoping will be with us after the COVID-19 pandemic. I plan on utilizing that going forward.
I think the only thing that you have to worry about in doing the remote hearings is whether they're critical stages. I mean, I agree with Charlie. You have to take pleas. You ought to take pleas in person, sentencing, things of that nature. That's where I think we need to balance the remote hearings with the legal rights.
Yeah. Well, I think about it from the standpoint of the attorneys also. When they're taking the plea, one of the things we're looking at is to make sure they understand what they're doing, that it's voluntarily done. They need to have their attorney available. With the Skype, what we've done, if that happens and they do need to talk to the attorney, we get off the call, let the attorney consult with the client. But again, I don't think that's optimum at this point. I'd rather do it in person.
No.
And, we're not having any problems with the in-person. I just this morning had 2 sentencings. We had public came in well within the COVID-19 social distance protocols. Nothing happened, no problems. Victims were there. I mean, those are interactive. The victims have the option and right to be there, and so do the defendants to have their people. These are, as Judge Lawrence and Judge Nelson and I've talked, they're public hearings other than juvenile proceedings, and we're doing our best to keep it that way.
Judge Lawrenson, have you had any online hearings where some of the parties or some of the witnesses tried to use another format like we're using here today, Zoom, and tried to handle it in light of you're typically using Skype? Have you had any situations come up that caused a conflict there?
No. Well, of course, the way in is through the Skype, either the Skype connection, which I think you have to download Skype for Business if you want, and it's a free program. It's with some, and it's available on OS formats and for PCs and for the Apple products. But the the only Zoom hearings I have done, or Zoom things I have done, have been for the state bar. So nobody has requested a different software setup. The software that has been provided to us and the account that's been provided to us by the Supreme Court of Appeals has been the Skype for Business. So that's what we've been using. it affords a call-in option. So if you don't want to download or use a laptop or do it on your phone, you have the option of just calling in, and you associate the number with the person that you're talking to. And of course, for those who are familiar with the Skype product, it does allow you to name yourself. So you have a picture and the person's name below, much as you're seeing now, and you are able to rapidly assess if you've got everybody you need to go forward. As far as people requesting other formats, have not, but of course, if someone could set it up, I mean, all I ask is that we have the opportunity to get our court reporter in with the same audio quality that everybody else is getting, and that is something that the telephone really doesn't offer very well. And of course, with the video portion of it, I can see her, and if she's having trouble hearing, and she has nonverbal expressions that help me understand that, I can have someone repeat what they said or clarify. It's been helpful to be able to see her when we're taking evidence or listening to argument, so that I know that she's able to make a good record.
This Judge Carl, in our
Thank you,
circuit,
Judge.
Judge Williams and I have done what they've requested with the business Skype. I have on occasion taken testimony from a witness. We had a doctor testify in an abuse and neglect case from WVU hospitals, and they use Zoom, and they stated that they had a HIPAA prescribed subscription with Zoom, and I had them vet that through Pat Motes down at the IT department. If you have questions, if it's secure or not, if you let the IT department, let Pat Motes know, they can check that out, and I'll let that doctor testify Zoom. But everything else, all of our hearings are through business Skype because there's concerns about the security. So that's what we've been doing, and that's another reason we're scheduling everything through our offices, so that we can be the host and can control the hearings that way. And we found that to work pretty appropriately.
Judge Nelson, I know that you have typically used a call docket. We had one earlier this week here in Grant County. How are things working out with the way you've been handling things on your call docket and with the rules that we're trying to implement?
Well, I mean, first of all, we're trying to make sure everybody's safe. That's the number one priority. But I found that the health departments, the sheriff's office, the bailiffs, those things, the clerk's offices, they're all interested in making sure that we meet the requirements of that the CDC put out for the state. And we don't seem to be having any problems with it. It really is going much smoother than I dreamed.
Does any of the judges have a grand jury coming up soon?
I have one next Thursday.
All right.
We don't have one here. We're continuing ours to September.
Right, what we're going to do is bring the grand jurors in, spread them throughout the courtroom, indoctrinate them, but keep them all 6 feet apart, indoctrinate them. Then when they start making presentations, we'll let them sit anywhere in the courtroom. They don't have to sit in the jury box.
All right. And will you have the defendants that have been indicted? I'm assuming you'll have them appear sort of like on your call docket at a particular time?
Correct.
Okay.
Correct. I think they're coming in the following Tuesday, 23rd.
Judge Lawrenson, do you have like a waiting room designated for parties and conference rooms available for counsel to discuss things with their clients at this time that are any different than you have been in the past?
Yes, it is different from the past. We have an administrative order in place that because of the size of the rooms, and we do have only so much personnel to do the cleaning after each use, the conference rooms that are just outside the courtrooms are left locked. We do have large hallways which have seating marked off at 6 feet intervals so that folks can, if they're waiting for their hearing, and actually I think it comes more into play at the magistrate clerk's office, and there's a marshal on that floor, and that they've got chairs spaced at the 6-foot intervals. And of course, the folks down front, they know how many people they have in the building for the magistrate clerk, if that's the business they need to attend to, and they limit it to the number of seats that are available at the 6-foot interval. So they keep account. It's a little bit like the grocery store or some of the other commercial establishments in the area that have basically limited the number of people in the building to maintain the social distancing. So it has changed to that degree. The physical plant hasn't changed otherwise. For our grand jury, we have a room that is fairly spacious and can be configured for 16 persons, a witness, court reporter, and the prosecutor assistant. So we're going to use our grand jury room and just space out the furniture. It's all movable chairs anyway, so it's no big challenge there. But I think the difference this year is I'm going to go into their room, instruct them where they are, and then leave them to their work, because the security setup is ideal for the grand jury as it is.
Judge Carl, I know you're in 3 different courthouses as you travel around the circuit. Have you implemented a spacing plan in each of the different courthouses in your circuit?
Yeah, Judge Williams and I met with the county commissions and then the health department, local health department officials, and got the maximum occupancy requirements and all that. And we've met with the bailiffs and the court personnel. And what we're doing is limiting the people coming into the courtroom. And we've changed the way we're doing our dockets now. We're just scheduling cases. We're not having everybody come in at the same time now. And that's helped out with the people congregating some. It's taken us a little bit more time on our dockets, though, because you're not able to go through your cases as quickly, of course. Like in Hampshire County, where we have a judicial center, we can accommodate 5 or 6 people in the waiting room downstairs, about that many upstairs, but we haven't been doing that. We're letting basically the on-deck case come into the courthouse if there's not too many of them, and then having either the attorneys or the bailiff contact people from outside to come in. And you said, Jay, each of our courtrooms are differently. In Hardy and Pendleton, they also have the county offices, and they're being administered that way as well. They're screened at the door. They may be temperature checked. They're going to be asked the COVID-19 questions. Hand sanitizing's there available. They're also told not to come if they have a fever, all the usual. But we're not seeing any problem with people coming in, and everybody's cooperated. The attorneys have done a good job with it, and their clients and the public, they've accommodated us.
Thank you, Judge. Judge Nelson, I know that there's been some science one way and the other on use of masks, but how's that been going in your courtroom, and what you're requiring with the attorneys and the parties and the people you're allowing in your courtroom?
Well, the parties and the attorneys have come in and handled it. I mean, judges, we tend to sit back and away, and we have to talk a lot, so I don't wear a mask. But most of the litigants have. But I mean, the only problem that you have, and you and I encountered this in Petersburg the first day back in court, Mr. Gary went to give an argument, which I'm sure was a wonderful argument, but I couldn't understand half what he said because he had a mask on. So there are times when I ask people to pull their mask out so I can understand what they're saying. But we've not had any problems. People who are court personnel, the DHHR workers, stuff like that, they all spread out all over the courtroom. Nobody's in anybody's face, and it seems to be going well.
Excellent. Judge Lawrenson, you have any comment on what you expect out of your attorneys and litigants and staff in the courtroom?
Well, mask wearing is required to get into the courthouse and get to the courtroom. Once we're in place and we have social distancing for the ease of communication, I'll frequently invite the speaker to remove the mask. It's frequently uncomfortable for them. It helps us understand what they're saying. I will wear a mask when I come in, just because I think if you're going to ask people to do it, you got to do it yourself. And since I expect it of the litigants and the lawyers, I'll do it. There's some proceedings, the mask never comes off. And then there's some where if someone looks like they're having a hard time hearing what I say, I don't project as well, perhaps as some of the lawyers do. If it looks like they're having a little trouble, then I'll remove the mask and speak more closely to the PA system. As far as seating, the seating is set up by security staff before I come into the room at the 6-foot intervals, and they're basically in charge of instructing you as to where you may be seated. If everybody comes together, like if it's a family that comes together, there's really no reason to separate them. So we don't try to separate people who came together. If a lawyer and a client wish to sit close together and confer, that's their choice, and I'm not going to tell them that they can't do that. So that's up to them. If they want to maintain their 6-foot distance, that's fine. It may be hard to discreetly communicate with your client under those circumstances, but if you're together, and that'd be an excellent instance where perhaps the mask should stay on for that purpose, and that helps if that helps them. I think the masks help us make Skype look like a better alternative, certainly for the folks that use the video feed, because it's kind of disconcerting. I mean, courthouses can have sort of an institutional and perhaps lack a warm and friendly feel as you come in, certainly if you're not used to it. Adding masks to everybody sort of is off-putting, at least to me. So the Skype hearings can actually be a little more congenial and friendly, and you can read the face a little better, and sort of see how people are reacting to what is being said, with a little bit more, the nonverbal cues come across better, and frankly, it's comfortable. To the extent that folks are willing to do it, and I've found a lot of folks are open to the idea, and the tech works for me, and I like being able to see the folks, and 20 feet away in a mask versus 2 feet away on a screen, full face, presents. If I can hear you well and I can see you well, I just soon do it by Skype at that point.
Okay.
We're doing the same thing in the 22nd what Judge Lawrenson's doing basically there, where if you enter any of our 3 courthouses, you have to have a mask on and keep it on until you're inside the courtroom you're going to. Then when you're speaking, you have the option of taking it off. If you're at counsel table with a defendant from the regional jail, you have to keep it on until you want to speak. And then I'm asking them to get up and speak towards the bench and not towards the defendant. But we're recognizing that, and the judges and everyone else, and that's the magistrate court, everything. We're all wearing them around the courthouse, like Judge Lawrenson said. We're not asking the public or the attorneys to do anything we're not doing. And once the hearings, once I'm on the bench, I'm not wearing it during the hearing because I'm quite a distance from the litigants and the parties. And I think it's important that they hear what we're saying, and vice versa. And if they have trouble hearing them, we're letting them take them off whenever they're speaking.
Judge Carl, I know you've probably got some jury trials that you've had to reschedule and move around and try to find time for, and you're going to have jurors uncertain about how to handle things and come into the courtrooms and maybe even respond. Have you guys put a plan together about your jury panel and your questionnaires and what you might do coming up?
Yeah. I have continued several trials that were scheduled in early July. The attorneys the attorney's request. And there's a lot of concern. I have concern about seating a jury panel. What I've done, and with Judge Williams' help, a letter that's going to go out with the jury questionnaires, basically just confronting the COVID-19 thing head on, saying that, we recognize that you're confused or scared right now with the COVID-19. We're asking you to come to a courthouse to possibly serve on a jury, requesting that they fill out the jury questionnaire form immediately and send it in. And then I go into depth about on page 2 of that, if they are a vulnerable individual, and even if they're taking care of a vulnerable individual where they feel they have a legitimate reason not to expose themselves to the risk of coming in or not comfortable, encourages them to send a doctor's note if they have one. If not, to expect maybe to be contacted by my office or the circuit clerk in that county. And what we're trying to do, I'm not trying to invite people to not serve on the jury. I give the standard, you're doing us a public service and clap on the back speech, of course. But telling them if it's a legitimate concern, that way we'll know, instead of spending half the morning eliminating vulnerable individuals or people that are taking care of their 90-year-old grandmothers and that, so that we can, when we do get a panel in, we're gonna have a better chance of that not being an issue, and we can get to the real important thing, which is getting a fair and impartial jury. We're going to space them out when we bring them in. We've talked, the trials that I did have scheduled, I talked to the attorneys about the possibility of bringing in a smaller panel and agreeing to pick one from that in the civil case. Criminal cases, I'm not too high on that, but on the civil cases, if they can agree to maybe a panel of 20 or 25 and agree to take 6 off of that. Just different things about strikes, but I haven't taken the leap yet with the jury. And our grand jury, you asked about that. We've decided in Hampshire County, at least, and I think in Hardy as well, not to have the grand jury. It was supposed to be the first week in June, and our prosecutors done a good job of getting out pre-indictment offers, and we've done some pre-indictment informations and gone through that process. But we didn't get a chance to try our cases from the January term yet. So that's the problem. And our next grand jury here meets in September. So our goal is to get rid of the January term and as many as we can before that. And Judge Williams is doing that in Hardy and Pendleton as well.
Judge Lawrenson, you have any trial set or plans moving ahead with your jury panels and selection process?
Well, we do have trials that were continued due to the judicial emergency, and we're in the process now of coming around and getting all those matters reset, of course, giving priority to those cases that involve incarcerated prisoners. Those are the top priority. In terms of the mechanics of it, honestly, that the jury box obviously is not going to be big enough to maintain social distancing, and I don't think I want to put a jury in a box and rely on just masks for their safety. So what we anticipate doing is using basically the right side, or the prosecution, the jury side of the courtroom behind the bar as a enlarged jury area for jury selection purposes, perhaps the entire back, to the extent that we may need it to seat a sufficient number of jurors. We're calling probably smaller panels. We're going to, in the clerk's office has traditionally called jurors instead, in addition to having them call in and get their number. I mean, our system here is you call in before each business day, and here, if your number has been called for jury service, if your number's called to come in, we're going to work harder on making personal contact with the jurors to verify that they are aware that they're to come in to serve, whether there's going to be any issues with that, and to try to deal with that before we have the morning of trial. And what we're going to try to do is make sure that even though we're going to have probably a smaller number net coming to the courthouse, that we have some more comfort level or some greater degree of confidence that the jurors summoned will serve. So that if we're changing something, those are the things. We're going to expand the confines of where the jury is going to sit so as to maintain spacing. And we're also going to reduce the gross number of jurors coming in so that you're going to have to broadcast your speech out. Of course, we're going to have the podium probably turned so that it's got a mic on it so you can talk and get into the PA system. But it is going to involve some changes of that nature. And obviously, we aren't authorized to conduct any jury trials yet, so we haven't had one in the new era. And I'm sure we're going to learn a lot of things. Another thing you probably ought to know is that we have 6 judges here in Berkeley County, or in the circuit rather, and everybody has different approaches. I think it is up to the judicial officer to conduct the jury trial in the fashion that they are comfortable with and that they believe will meet the needs of the particular case. Some cases prove more difficult to pick juries than others. Sure. I want them to feel comfortable. We have batted around some ideas amongst ourselves, and it's hard to tell when they're joking. Sometimes you hear, there's a California style. Had some folks come from a case that was tried all over the country, and they said, well, in California, you have to stand up and point at the jurors and say, I wish to exclude that one. So maybe we can come up with some social pressure, some peer pressure to get more jurors acceptable. Because frequently,
Jay, this is Anita. I have a question that came in. It's directed to Judge Carl, but I think it's appropriate for all the judges. And that is, have you had any problems finding folks willing to serve on the jury? Judge Carl, directed to you first, please.
We haven't had that yet. We haven't sent out any questionnaires for any the juries but it's going to be they're going to be going out. We have some trials scheduled in July, but we haven't had any response yet. If you're referring to the letter that I was going to send, I was going to send that out with the jury questionnaires through the circuit clerk's office, but we haven't had any problems yet because we haven't tried.
Thank you. Judge Nelson, we're getting sort of close to our time. Maybe you want to share something about any ideas or thoughts you have on jury trials coming up, and maybe just give us a little closing comment or summation on where you're at with this and what you'd like moving forward.
Okay. What we need to realize, and getting back to a second ago, nobody's ever liked to serve on a jury long before COVID-19 ever showed up. I never understood until I became judge how many you might put 300 people on the list, and 300 of them, or 295 of them won out. So, I mean, nobody likes to do jury. The only thing we can do as a court system is make it accommodating and as safe as possible. The attorneys have done a good job. I understand they're having problems keeping in contact with their people at the jail. And if they need assistance, certainly they can come to the courts and we can help coordinate that. But I think we are doing a good job. We just need to continue it, and hopefully this thing's going to get behind us here for a while.
Thank you, Judge. Judge Lawrenson, you have a closing comment?
Well, thanks for the opportunity to speak to the bar at large about what's going on in the courthouses. I think it's important that they gain some understanding as to what they're going to be confronting when they come to the courthouse. Some things have changed. So I do appreciate the opportunity. I think the bar had a good idea in letting us have this communication and exchange of ideas. It might come to pass that in the coming months, as we do the grand juries and the jury trials, that we're going to learn from some experiences as to how jurors are receiving the precautions they're being asked to undertake. In terms of, I think Judge Nelson is correct in that any quantity of people asked if they would like to serve on a jury will likely tend not to until they're there, and then they realize I think the importance and solemnity of the proceeding does weigh on folks, and in my experience, they've all taken it seriously. But I do appreciate the opportunity to communicate with the bar in this fashion so that they could have some comfort that these issues are being addressed, where to go for resources. There is an administrative order that tells you what you need to know. We haven't found an effective way to get that out to the public yet, but it is available if you wish to obtain it. And I think we furnished it to the bar in association with this program. But thanks for the time with the bar. Appreciate it.
Thank you for your participation. Judge Carl, do you have some comments in closing?
I would just say that we all need to keep in mind this is a fluid situation. There's no precedence. Nothing's written in stone. We're doing things that we never dreamt we'd be doing right now. If you have a situation where you need someone accommodated, or you have a party that you're worried about, or they've had problems, I think if you call your judges' offices and speak to opposing counsel, we're trying to be as creative as we can to meet the needs of the parties and the litigants, and still command justice. So we're looking at different ways for people to testify and accommodate witnesses, even having the hearings themselves. I've had hearings where we have in person, on Skype, and on telephone. So don't hesitate to talk to your opposing counsel and call the judges, because we're all sharing your pain here. We all want to get these things done, and we all need to work together, and have been. And I just want you to know we all have an open door policy about how to conduct these hearings, and we're going to learn from what other jurisdictions do on how to handle these trials and so on. But there's nothing written in stone, is what I would leave you with, and that give us a shot at hearing what you want to do, and we'll see what can be done.
Thank you, Judge Carl. Anita, you want to come back on and close us out?
I would. The three judges today have graciously agreed to allow this webinar to be recorded. As soon as Mike Mellis has the video available, he will share it with the judges. Once they give us the okay, it will be posted on the website. We have at least 27 hours of free CLE already posted. So with this webinar, it will give us 28. So everyone should be able to complete their credit this year with no difficulty. After this webinar, you will receive an email from the State Bar that says you attended. You must accept that. You cannot let it sit on your computer. It will not go on your transcript. Once you get it, please confirm that you got it, and it will go on your transcript. As noted previously, these types of webinars, we are only getting State Bar credit for West Virginia. If you are seeking credit in another state, you will need to follow their procedures. Unfortunately, we don't have sufficient personnel or financial ability to complete forms for attorneys who are in other states, so you will need to handle that on your own. As of right now, this is our final judicial webinar, but we have in the works the possibility of a few more, so I will ask everyone to continue to watch the Bar Blast. We've had good responses, especially since COVID-19 started, with our Bar Blast. It's our best way of communicating weekly with our members. So I'll wrap up there and thank Jay and thank our three judges, and tell everyone goodbye. Have a good weekend.